Good afternoon, everyone, and welcome to another question and answer session live. My name is Samara Belitzky, and I'm an employment lawyer at Samfiru Tumarkin, and I work out of our Ottawa office. But I'm here, as I am many Fridays during the year, to answer all of your questions related to employment law, related to workplace issues, any issues in the workplace regarding safety, terminations, severance, changes to workplace conditions, any issues related to COVID, whether it be a layoff or perhaps a vaccination issue that people seem to be still experiencing. Whatever it is, if it's on your mind, send in your question. Happy to answer all of your questions for the next 30 minutes or so. And as we wait for some questions to come in, as always, I have a few topics that I had prepared to discuss, things that have come up a lot this week, whether it be questions from people contacting us or things in the media. There seem to be a few things that have come up a lot over the last week or so. So I'll start off with the one that seems to be kind of at the forefront lately, and then we'll see if we have time to get to the other issues, depending on how many questions we get today. So if you're watching, send in your questions. Like I said, here for the next half an hour, I will get to as many questions as I possibly can. But as I said, I will be talking about the first topic that's been in the news a lot this week, and that we've been getting a lot of questions about, which is quiet quitting. You might have heard of it. You might have seen this term referenced online. You may have seen it on an article on the internet or something on TV about it. This is something that started to become trendy actually on TikTok online, and it's now kind of trickled out to the rest of the world and different forms of media. And essentially, it's a principle, and it's something that's come out, I think, mostly because of the pandemic, where a lot of people have been working remotely, working from home, and we've really seen kind of a blurring of lines between the work-life balance, where it was a lot easier to keep work and personal life separate before. During the pandemic, and it continues even now, it's a little bit more difficult when you're working from home. And so this obviously doesn't apply to everybody, but it does apply to enough people that this has become a trend. And what quiet quitting essentially is what it's being referred to as is essentially somebody only carrying out the essential duties of their job, what they were hired to do, nothing less and nothing more. So no extra hours, no additional duties that aren't the duties they're supposed to be doing, that are not part of their regular duties. Essentially not going above and beyond and just doing your job, like I said, nothing less, nothing more. Now, this is kind of a buzzy word, and it's a new topic that has come up in conversation recently, but it's not a new principle. And this is something that many people have been doing for many years. And as an employee and as an employer, there are a few key takeaways about this exact situation. So the first is that when it comes to carrying out duties as an employee, the employee absolutely has the right to just do what they're supposed to. In other words, there's no obligation for an employee to do more than what they were hired to do, to either work more hours or to do more in terms of duties. So an employee is well within their rights to just stick with what they were hired to do within those parameters, whether they be duties or hours, whatever the case may be, and just stick with that. Now, where there can be some difficulty is if, let's say, an employee does start to take on additional duties or start to work additional hours, and this goes on for quite some time, that's where the employee would have an issue after the fact, then refusing. So if you're somebody who over the last year or so, you've taken on additional duties and you've been carrying them out, no problem, no issue, you haven't refused anything, you haven't raised an issue to your employer about it, those new duties actually become part of the terms of your employment. And so it's really important as an employee, when you're confronted with any changes to the regular terms of employment, whether that be extra duties, whether that be the removal of duties, whether it be a change in position or a change to your hours, it's really important to get legal advice on these things right away. Because if you don't act on these things right away and express your refusal in writing to your employer with the advice of an employment lawyer assisting you along the way, then you do run the risk of being deemed to have accepted those changes. And if you've accepted those changes, you can't then go back afterwards and do something about it. So when we're talking about this concept of quiet quitting, if an employee has been doing extra work and going above and beyond for quite some time, that then becomes the standard. That becomes the regular terms of employment. And you wouldn't be able to, as an employee, all of a sudden refuse to do those things that you've been doing for quite some time because they've become part of your job. So that's why it's very important as an employee to be very careful when these things are happening and act on it immediately. Now, if you're in a situation where these issues are coming up for the first time, then you can refuse them. If an employer is trying to make changes that are significant and permanent changes to the terms of your job, to your work conditions, you do have the right to refuse it. And you should do that in an express way, meaning in writing, so that you have a record of it to make sure that it's clear that you've refused it. Now, moving forward, if after you've refused it, the employer is still forcing these changes on you, that's when you might be able to treat those changes like a termination of your employment and go after your severance. And that's where we would get involved and assist you. But again, you always want to be getting legal advice at the outset, right away. Don't quit outright. Don't do anything that could potentially harm your legal position or harm your potential case. Get in touch with an employment lawyer right away. Get in touch with us so that we can assist you to make sure that you are doing what you need to be doing. You're following the steps that you need to follow to make sure that you're in a strong legal position. You can always call us. You can go to our website at employmentlawyer.ca, and you can also email us at help@employmentlawyer.ca. So there's many different ways you can contact us. If you're going through a situation like this, where there are changes happening and you're not sure if you should accept the changes, refuse the changes, if your employer is allowed to do this or not, get in touch with us, speak with an employment lawyer before you do anything, because it's very important to protect yourself from that point forward. So going back to this kind of concept of quiet quitting, this trend that we keep hearing about, if you're in a situation where you're refusing to go above and beyond for the first time, while technically from a legal perspective, you're allowed to do that. You don't have to go above and beyond. You don't have to do more than you were hired to do. There is a way that I would recommend addressing it, and that's speaking with your employer, having a direct dialogue with your employer rather than just an outright refusal, because that way you're keeping the relationship positive, and you're also eliminating the risk of potentially being let go. Because even though you're not required by law to do these additional things, it may be that an employer decides to let you go. And the employer does have the right to terminate without cause, meaning a regular termination at almost any time for almost any reason, as long as it's not discriminatory. So what that means is the employer is allowed to do that as long as they give you what you're owed at law with respect to a termination, whether that be working notice or severance pay or a combination of the two. But whatever you are owed as part of your termination entitlements, as long as the employer gives that to you, they are allowed to terminate your employment. And so you want to be careful in a situation like this, because you may end up in a situation where you could lose your job. You'd still get severance, you'd still get what you're owed, but you would be out of a job. And so if that's something that's important, that you don't want to have a situation like that happen, you will want to tread carefully when dealing with these situations. The other thing that's important to know about this issue is if you are going to refuse these additional duties being asked of you, especially if, let's say, you're being asked to work more hours, you'll want to make sure that you do it in writing as well to have protection in case your employer then fires you because of it. If you refuse overtime hours, you are protected by law. By law, you are allowed to refuse overtime hours, and this is just one example, but you are allowed to refuse overtime hours, and the employer cannot retaliate against you. They cannot commit reprisal. That means they can't discipline you because of it, they can't treat you differently, and they can't fire you because of it. Okay, so as long as overtime is not part of the terms and conditions of your employment that you agreed to when you first started, they can't force you to do overtime, and they cannot fire you because of it. So make sure that if you're doing anything of the refusing, anything in the nature of refusing additional duties or hours, you do it in writing. I would always recommend having a discussion with the employer and keeping a dialogue open to keep a positive employment relationship. But you still need to protect yourself by putting it in writing so that if ever this does come to a head and if ever this does become a further problem in the future, you have that to rely upon. On the employer end, if you're an employer watching, what I would recommend you do is have very, very clear-cut job descriptions in place. If you have clear job descriptions where the expectations are clear, the duties are clear, the main conditions of employment are clear, that provides clarity for both the employer and the employee, and it can really help avoid confusion about what's part of someone's job, what isn't part of that person's job, what would be considered going above and beyond, what's an additional duty that's outside of the regular parameters of somebody's job, and so on and so forth. And it can really help with eliminating confusion about these issues so that hopefully you don't get to a point where you're having an employee refuse to do things, or as an employee, you feel like you're being asked to do things that you shouldn't be asked to do. And so that is one way that you can really prevent some of those things from happening. So I've tried to give as much as I can on this topic. This has been in the news all week long. I've had lots of questions about it. So hopefully for all those who are watching today, this does provide some clarity on this topic, because it can be a bit of a confusing topic when you hear about, quiet quitting in the news. You think automatically, people are quitting their jobs, or they're, quitting without telling their employers. It can be a very confusing concept to hear about in the news, but hopefully this gave some, clarity on the issue, and as an employee or an employer, what to do about these particular issues. When in doubt, you can always contact us. If you're not sure about what to do, you can go to employmentlawyer.ca. You can contact us on our website. There's all of our contact information. My personal contact information is there as well. If you have any questions about this or anything else, you can always contact me directly as well. So as I've been talking, I've had quite a few questions come in. So I'm going to get to some of the questions now, and then we'll see if I have time to get to the other topic that I wanted to talk about today. So I'm going to get to the questions. We have a question from somebody on Facebook who says, can you be terminated while you're on vacation? Does this factor into what you're owed in terms of severance pay? That's a very good question. So generally, yes, you can be terminated from your employment while you're on vacation. There is no law that prohibits that says that the employer can't do that. Personally, I think it wouldn't be a very nice thing to do. I don't think it would be a good practice as an employer to do that, because you're ruining somebody's vacation, and it doesn't lead to kind of an amicable end to the employment relationship. But from a legal perspective, it is allowed. It is permitted. Now, whether that factors into severance or termination entitlements, it doesn't. So whether someone's let go on vacation or not on vacation, they would be owed the same amount of severance regardless of that timing. There are other things that do come into play. For example, if you're on a medical leave or a parental leave, those are leaves where the employer does not have the right to terminate employment. So if you're on a medical leave or you're on a maternity leave, for example, the employer cannot terminate your employment during those times. But a vacation works a little bit differently. It's not a protected leave by law. So that means that the employer can terminate your employment during that time while you're away. And now when it comes to severance, whether you're let go on vacation or not, it won't impact how much severance you're owed. The things that will impact how much severance you're owed generally are things like your age, your length of service, the kind of job you have. Those are the things that we generally look at. If you're ever not sure, how much severance you could be owed, what you might be owed, we do have the Pocket Employment Lawyer at pocketemploymentlawyer.ca that you can use, and you can find out an estimate of how much you could be used based on certain factors. So that gives people a very good estimate of what you could be owed. It isn't a substitute for legal advice. So if you want an absolute bang on estimate of your severance that's going to be coming from an employment lawyer, you get in touch with us, speak with us, and we can give you that legal opinion. But the severance calculator and the pocket employment lawyer are great tools to use if you're just curious about what you might be owed. Now, in terms of severance, as I mentioned before, depending on those factors that I mentioned, that is what will determine your severance, not whether you would be let go during your vacation or not. However, if you are let go during your vacation, it can impact how much vacation you're owed at the end of your employment, because generally speaking, vacation that you've accrued up to the date of termination would be owed. Whether you quit or you are let go, any vacation you've accrued up to your last day is automatically or should automatically be paid out to you at the end of your employment. Again, that's the end of your employment, whether you've quit or you've been let go. Up to your last day, you continue to accrue vacation, and then it would be paid out. The difference with a termination is that following your termination, you still continue to accrue vacation and vacation pay, and it would be for the amount of weeks that you're owed as a bare minimum under the Employment Standards Act. So if, for example, you have 10 years of service, your bare minimum under the Employment Standards Act is 8 weeks of notice or termination pay. So for 8 weeks following your termination date, you would continue to accrue vacation pay. And so in that scenario, you would be owed all of the vacation that you've accrued up until your last day, and then the vacation that would accrue during your 8 weeks following your termination. The 8 weeks is just in the example I've provided. Depending on your length of service, that amount of weeks that you continue to accrue vacation for will differ. It will vary depending on your length of service, but there is additional vacation accrual after a termination. So keep that in mind, because if you are let go during your vacation, then that can impact how much you would be paid out compared to, how much vacation you might have taken during your employment. So that will have an impact, but you are still going to be owed the same amount regardless. Okay, I have a question from Janice on YouTube, who asks, how much notice is required to give an employer if you plan on resigning? So this is a great question that we actually get very often. I find I get this question almost every single time I do a live question and answer session. So it seems to be something that's on a lot of people's minds, and for good reason, because you're leaving your employment, you want to make sure that you're complying with your legal obligations, you're leaving on a good note, and you don't want to have anything following into your next stage of your life and of your career. So generally speaking, 2 weeks is the standard. That's the standard practice in terms of making sure that you are not leaving your employer in a difficult position. Having said that, a lot of the time, employment agreements will specify how much notice you have to give. So if you do have an employment contract, a written employment contract that you've signed, either when you first started or at some point during your employment, there might be a resignation section in there that specifies how much notice you have to give. Usually it's 2 weeks, sometimes it's 3 or 4 weeks. I'd say generally speaking, if you're going to be signing an employment contract, 4 weeks is the most I would recommend that you agree to. I think anything more than 4 weeks is not reasonable unless you're in a position that's very exceptional where the company would need more than that. And maybe it would be reasonable in some circumstances, but generally speaking, more than 4 weeks would not be reasonable for notice of resignation. And the bare minimum, I'd say generally would be 2 weeks. So you have to think about, if you're going to resign, what is the position of the employer going to be? And you want to make sure that what you do in terms of giving your notice of resignation is make sure that you're giving enough notice so that they're not put in a precarious position by your termination, or try as much as possible. Sometimes they will be put in a bad place or a bad position no matter what by you leaving, because you're a big value and a big asset to them. You can't do anything about that, unfortunately. But if you can give the proper amount of notice, at least you can assist in that transition, and then you can walk away with your hands clean, knowing that you've complied with your own legal obligations. I have a question from Carrie on YouTube, who says, I don't have an employment contract at my current job. Should I advocate to have my duties outlined? Can my employer claim that I have additional responsibilities without having a contract? So if you don't have an employment contract at your current job, that's not necessarily a bad thing. Generally speaking, employment contracts will be favorable to employers. So as an employee, you don't really want to have an employment contract, a written employment contract in place, because most often when you do, it's because the employer is trying to limit their liability. Usually it's for termination entitlements, but it will be for a few different things where they're trying to essentially increase their own rights, decrease their obligations, and limit their liability to the employee. So it's a good thing, actually, Carrie, that you don't have an employment contract written in place. Keep in mind that just because you don't have a written contract doesn't mean you don't have an employment contract, because an employment contract is still formed when you start working for an employer. You have an agreement on the job that you're being hired to do, your hours, your pay. That is an employment contract. You start working for them and then they pay you. That's still an employment contract. It's just not in writing. So no matter what, you would still have one, just not a written one. And the written one is what you want to look out for as an employee, because that's where you get into things where the employer is trying to protect themselves. So I wouldn't suggest that you try to get an employment contract or suggest that to your employer, because that's not going to help you. It's only going to help them. What you could do is you could have, could put in a request to have all of your duties outlined. I do recommend that this be something that you address when you start a new job so that everyone is on the same page and you're sure of it. But if you've already started and it's in the middle of your employment, certainly you can have that conversation and you can have a discussion. I would recommend having a discussion with the employer about it and then following it up with something in writing. Sending an email saying, as per our discussion, here's what we discussed. Here are the duties. Here are the expectations in this role, and have there be an agreement that way. And that way, at least you have it in writing. You've discussed it. Everyone's on the same page, and moving forward, there shouldn't be any issues about that. Now, to address your second question, can your employer claim that you have additional responsibilities without having a contract? No. So whether there's a written contract or not, that's not going to change anything. Your duties are your duties. Your responsibilities are what they are in the role that you were hired to do. And they can't add to it just because you don't have a written contract. And sometimes what I see is even if somebody does have a written contract in place with a job description attached to it that outlines the duties, that doesn't prevent employers from still trying to have them do other things and add to it and add to it. So a written contract really isn't going to change anything when it comes to that. Employers are either not going to do it or they're going to do it regardless. So again, what you can do to protect yourself, as we mentioned a little earlier during this session, is make sure that you know what your job is. Have it clearly outlined. Make sure there's an understanding about it. And you will know, I speak to people about this issue all the time. If your employer is trying to put additional responsibilities on you that aren't yours, that traditionally have not been yours, you should be addressing it with them. Sometimes it's temporary because somebody quit, and until they find a replacement, they just need you to pick up a little bit of the extra slack. If that's the case, put it in writing. Put it in writing that this is only temporary. You're only agreeing to do this for a very short period to allow them to find a replacement. That way, those are not permanent changes to your job. If there is no agreement that it's temporary, if you start doing these additional duties and there's nothing in writing that addresses it being temporary, then that becomes a term of your employment moving forward, and it's very hard to go back on that. So you have to be very careful about that issue. So in terms of the additional responsibilities, you always have the right to refuse them if they're not part of your job, and you should absolutely be voicing that refusal and expressing that refusal to your employer. Like I said before, it's good to have a meeting about it. It's good to keep a positive dialogue going with the employer, but then you also have to follow it up with an email to protect yourself so that you have everything in writing if the issue doesn't resolve and there is a problem moving forward. I have a question from Anna on YouTube who says she's on maternity leave. If I lost my job upon return, would my severance pay be based on my maternity leave pay or the position of service I had prior to going on maternity leave. So if you lost your job upon return, your compensation and your severance is based on your compensation at the time of termination. So whatever your compensation would be at the time that you return to work, or at the time, generally speaking for everybody, when you're let go, it's based on the time of termination. So whatever your compensation might be, whether it's a salary, whether it's a combination of a base salary and commission payments, whatever the case may be, it's at the time of termination. That's what it's based on. So with respect to your question, Anna, I'm not sure what you mean about your maternity leave pay. If you're talking about EI, maternity leave benefits, your severance would not be based on that number. It would be based on your actual compensation from your employer at the time of termination. If, let's say, you were let go immediately upon return, and I'm going to get to this issue in a second, but if you were let go immediately upon return, which is illegal, but if that were to happen, it would be based on the compensation in place at that time, which I expect would be pretty similar to what your compensation was when you went off on leave. The only exception to that being maybe that your company implemented company-wide cost of living increases or salary or raises across the board. So maybe you had something come into place that increased your compensation while you were off on leave that's going to apply when you come back to work. So that would be included in determining the number that your severance would be. So I hope that answers your question. If not, feel free to send a follow-up question on that issue. Now, I will say in terms of returning from maternity leave, I touched on this earlier, but maternity leave, parental leave, is a protected leave by law. That means that an employer cannot let you go while you're on that leave. It also means that you have to return to work after your leave. In other words, your employer can't fire you, the day that you come back from a maternity leave. You have to be accommodated. This is a job protected leave. And on top of that, an employer cannot let you go because you took a parental leave, maternity or otherwise. And that's protected by the Human Rights Code. So if an employer lets you go because you took a leave of the kind that we're talking about, that would be discriminatory. So not only would that termination be illegal, but there would also be a human rights claim involved in certain situations where that would happen. So if you're in that situation, it's important to get in touch with us right away so that we can review the situation with you and let you know what your options are. I have to say, unfortunately, I see this way too often. I've had quite a number of clients who have been let go during parental leave, during maternity leave, or right when they're coming back from it, the same day or 2 days before they're supposed to go back. It's absolutely terrible. It's something that as an employer, you should never be doing. And it really, as an employer, exposes you to significant liability, not just for severance, but also for potential human rights damages. So as an employee, you would have the ability to pursue these things. You would be owed your severance. And like I said as well, there would be a human rights angle to this as well, because you were on a protected leave and you have protections afforded to you by law for having been on maternity leave and returning to work. So when you return, it's supposed to be a return to work, everything the same as before, same terms and conditions as when you went off on leave. If, let's say, your job doesn't exist anymore because there was a restructuring that took place while you were on leave, then the employer has an obligation to provide you with the next best thing. In other words, a comparable role, a similar role. If there is no comparable or similar role and there's nothing that's similar that they can offer you, then you're going to be in a situation where the employer has to provide you with a severance package. They can't put you in a lesser role. They can't demote you. They can't pay you less. They can't make any of those changes. If it's not the same or a similar role, then it's a termination and you're going to be owed a severance package. Now, I know I have a couple of questions here I didn't get to. If I didn't get to your questions, as you would have just seen, we have more live sessions next week. There's another one on Monday. There are quite a few throughout the week, so you can always ask your question at that point. If not, you can also contact us. Go to our website at employmentlawyer.ca, and you can contact us that way to get your questions answered if you don't want to participate in the next session. So that's it for us today. That's all the time I have. Thank you everyone very much for your questions, and I hope that everyone has a wonderful weekend.